Hello, my dear students. I am Dr. Manoj Sharma. Today, we shall be discussing the topic dumping and anti-dumping law. I will start the topic with a quote by Eugene V. Debs. He says, "Sooner or later, every war of trade becomes a war of blood." Trade wars are a reality, especially in the context of a globalized world, where the international sale and purchase of commodities has become much easier than ever. The opening up of markets in the developing and underdeveloped countries has provided avenues to the multinational players and even countries to exploit the foreign markets. The contemporary times have seen markets of developing and underdeveloped countries being flooded with international products at much cheaper prices than the domestic price of such products. This is due to the fact that sometimes profit making from every transaction is not the sole purpose for the business and countries. International trade may be carried out with various other purposes, including but not limited to gaining a competitive edge in the international market, destroying competition in the foreign market, damaging the local producers in a foreign territory, and gaining control over the trade and business in that country. Or it may be making a space for its products, etc., thereby losing in the short term but intending to gain big in the long term. And how do we achieve this? The device used for these purposes is the selling of goods at a price that is lower than the price of that product in the domestic market, or sometimes by charging a price that is even less than the cost. Now, the first question is, what is dumping? Term dumping is relevant in the context of international trade. Dumping refers to the act of selling goods in a foreign market at a price that is lower than the price at which they are sold in the domestic market. The premise of international price disparity is fundamental to the definition of dumping. Jacob Weiner's 1922 definition of dumping remains relevant even today. He defines dumping as a practice that involves pricing goods at different levels in different national marketplaces. Dumping thus refers to the practice of exporting goods at prices that are lower than the prices charged domestically. Dumping may involve not only selling products in a foreign market at a lower price than in the domestic market, but may also involve undercutting prices below the average expenses or the marginal costs. There are various factors affecting dumping, such as market segmentation, market dominance, and market responsiveness. Market segmentation is essential for dumping to occur, as it allows exporters to protect their home markets from secondary markets. Market segmentation is frequently facilitated by the global landscape, which is influenced by factors such as product differentiation, variances in taste, trade policies, regulatory inequalities, and differing product standards. As a result, the commercial environment often provides chances for intentional or unintentional price dumping. For successful dumping, the exporting company must possess substantial market dominance in the target country to effectively manipulate prices. Further, if foreign markets are more sensitive to price fluctuations compared to domestic markets, it creates favorable circumstances for engaging in dumping. In short, dumping is a multifaceted occurrence in global commerce that involves selling products in foreign markets at prices that are lower than those in the native market. The incidence of this phenomenon is determined by various factors including market segmentation, market power, and price elasticity. The incidence of this phenomenon is determined by various factors including market segmentation, market power, and price elasticity. Now let us discuss reasons for dumping. Dumping, an often observed phenomenon in international trade, owes its existence to a number of reasons, each of which represents distinct market conditions and strategic behaviors of exporting companies. Economists have identified various factors that contribute to dumping, each with distinct goals and presenting specific challenges to both domestic sectors and international trade restrictions. A typical cause of dumping is when exporters face closed domestic markets. When enterprises face regulatory hurdles or intense competition in home markets, they may choose to sell their surplus production at lower prices in foreign markets that have more favorable demand conditions. This strategy capitalizes on disparities in market conditions between the exporting and importing nations, enabling exporters to optimize their profits. Moreover, the presence of anti-competitive behaviors in the exporting country market can contribute to the occurrence of dumping. Government subsidies can contribute to the practice of dumping. Government subsidies given to exporting companies can artificially reduce manufacturing costs, allowing them to sell items at rates lower than the actual market value. This practice of distorting competition in importing countries raises issues about market fairness and necessitates governmental intervention. Now let us discuss types of dumping. The question is how to analyze whether there is dumping. The process of identifying dumping entails the comparison of product prices in two separate markets. The market of the country from which the product is exported, referred to as the normal value, and the market of the country in which the product is imported, referred to as the export price. The analysis, as stated earlier, is complex and it involves consideration of various variables such as temporary or sporadic dumping, persistent or ongoing dumping, predatory pricing, etc. Each category emerges from distinct motivations and conditions. This takes us to types of dumping. First, sporadic dumping. Sporadic dumping is not persistent but occasional. There may be cases of temporary dumping when the foreign enterprises have excess inventory and they want to dispose that off in another market to avoid a price war in the domestic market and to have access to international markets. This ensures that not only their excess inventory is disposed of, though at a lower price, but also that they will be able to convert the surplus inventory which was lying unproductive into revenue. Secondly, predatory dumping. Predatory dumping practices are intentional undercutting of prices. These practices are strategized to eliminate competitors from the overseas market. For example, XYZ wishes to enter the Indian market in a particular sector and dominate the same. So what they do is they start exporting their products to India and selling the same at less than the cost of the product, habituating people to use their products. These practices result in unfair competition and inefficiencies in international trade. Predatory pricing methods are designed to achieve market dominance and create monopolies in the long run. The enterprises would be able to recover losses suffered during the period of undercutting prices once the market dominance is achieved. The enterprises view below cost pricing in foreign markets as an investment in future market potential. As explained, ultimately, these strategies impair consumer welfare and suppress competition in the long run. Thirdly, persistent dumping. Persistent dumping, as the name indicates, refers to the continuous export of products by a foreign entity to another nation at a lower price. This dumping is persistent, continuous, and sort of permanent. This is a serious cause of concern for the importing countries. There have been instances in the international trade where the enterprises would sell their products at higher prices in their own country because there is no competition at home, and would sell the same product at lower prices in foreign markets consistently to gain a competitive edge. The losses are recovered from the domestic market, and by gaining a larger share of the market in foreign countries. Fourthly, reverse dumping. When the demand of the product in the foreign market is inelastic and is not affected by an increase in price, and the domestic market conditions are favorable for dumping, reverse dumping takes place. By reverse dumping, we mean when the enterprise sells the product at a lower price in the domestic market and charges a higher price in case of exports, recovering the losses and costs from the exports. The persistent dumping and predatory pricing practices compelled the governments to come up with anti-dumping measures. Now, the question is, what is anti-dumping? Dumping, therefore, is a cause of concern for governments and is considered an unfair trade practice. To tackle the issue of dumping, a comprehensive strategy is needed, which we call anti-dumping. Anti-dumping involves implementing robust competition laws and anti-dumping measures. These policies aim to establish equitable and competitive markets that not only protect consumers but also foster sustainable economic development. The purpose of these actions is to correct the imbalance caused by dumping activities and to ensure equitable competition in global marketplaces. Therefore, anti-dumping measures are taken to deal with the dumping situation. These measures are taken by the country where the products are dumped as a regulatory mechanism to deal with situations when dumping leads to significant harm to the domestic market. The next question is, what are anti-dumping measures? Anti-dumping measures include imposition of anti-dumping duties on imports. For example, if a company sells the product in its domestic market at a price equivalent to rupees 50,000 and it exports the same product to India at rupees 45,000 to distort the Indian market, the Indian government can impose rupees 5,000 as anti-dumping duty as an anti-dumping measure if dumping is established. A glance into the history would show that the anti-dumping duties were resorted to by the developed countries to protect their own markets, starting from the early 20th century and continuing until the wake of World War II. Industrialized nations implemented anti-dumping laws in response to worries about unfair trade advantages. Countries such as Canada, New Zealand, Australia, South Africa, Great Britain, and the US aimed to counterbalance perceived drawbacks experienced by their home industry because of foreign producers. As a result, anti-dumping duties were imposed to address the market distortion produced by dumping tactics. Nevertheless, it was not until the 1920s that the matter garnered global recognition. The General Agreement on Tariff and Trade GATT, which was founded in 1948, achieved a notable breakthrough by incorporating Article 6, which expressly deals with anti-dumping and countervailing duties. Article 6 established criteria for implementing anti-dumping duties, stating that these measures may only be implemented if the price of the imported product was lower than the price in the local market and if it was clear that the domestic industries would be harmed as a result. Notwithstanding this early endeavor to regulate, the process was deficient in enforceability and accuracy. Significant advancements were not achieved until the Kennedy round in 1967. The GATT anti-dumping code was implemented, imposing enforceable responsibilities and offering instructions for the implementation of anti-dumping measures. This signaled the initiation of a more organized and systematic strategy for dealing with dumping practices. In 1979, the Tokyo round saw additional improvements made to the anti-dumping code. Modifications were implemented to distinguish between anti-dumping and countervailing duties in response to concerns expressed by institutions like the European Commission regarding the understanding of criteria specifically in the United States. In addition, provisions were included to recognize the unique situations faced by developing nations when implementing anti-dumping measures, highlighting the importance of fairness and thoughtful consideration in trade relationships. This served as the basis for anti-dumping provisions described in Article 4 of the General Agreement on Tariff and Trade 1994, that is GATT. GATT not only recognized the need for anti-dumping measures but also explicitly condemned dumping as an unjust trade practice and provided the legal foundation for implementing anti-dumping measures. Whether there should be anti-dumping measures or not, whether trade and commerce should be free, these are the questions that have perplexed policymakers and economists for a long time. Proponents of anti-dumping measures contend that these rules safeguard domestic industries by restraining unfair competition. They contend that anti-dumping rules are essential for ensuring fair competition in global commerce by tackling unfair practices and safeguarding home sectors from unwarranted damage. Whereas opponents of anti-dumping measures argue that such measures hinder market efficiency and the free market principle, and these measures unfairly raise prices. Despite ongoing disagreements over their effectiveness and economic consequences, anti-dumping measures remain a crucial part of global trade framework, influencing the dynamics of international commerce. Now let us discuss anti-dumping agreement. To tackle dumping, the World Trade Organization WTO came up with anti-dumping agreements in 1994 during the Uruguay round of negotiations. This agreement allows member countries to take anti-dumping measures to protect local markets. The anti-dumping agreement provides precise regulations for the implementation of anti-dumping actions by the members of the WTO. WTO has also established a committee on anti-dumping practices to monitor members' adherence to anti-dumping regulations. Under Article 16, WTO members can deliberate upon the implementation of anti-dumping agreement and the matters connected therewith. The WTO further provides information by the concerned member country to the committee about any initial or final anti-dumping measures to ensure transparency and accountability in anti-dumping proceedings. The anti-dumping agreement is primarily focused on establishing specific regulations that determine the circumstances in which anti-dumping measures can be enforced. These measures are primarily implemented in response to requests from domestic industries which compete with imports. The agreement specifies the conditions for starting and carrying out investigations on anti-dumping, establishing the margins of dumping, and implementing and evaluating anti-dumping measures. Three approaches are established for determining the typical value of a product: utilizing prices in the exporter's own market, pricing in a different country, or a calculation including manufacturing costs and profit margins. This rigorous technique seeks to prevent the arbitrary establishment or exaggeration of dumping margins. The agreement also provides procedural regulations that govern the commencement and execution of anti-dumping investigations. These norms envisage written applications which must be substantiated with proof of dumping, injury, and clear causal connection between the dumped imports and the harm inflicted on the indigenous industry. Further, as per WTO norms, investigations into dumping must be concluded within predetermined timeframes, usually 1 year. Thus, the World Trade Organization regulates anti-dumping measures on a global scale, following a set of regulations that control international trade. Although the WTO does not interfere with the operations of corporations involved in dumping, it offers member countries valuable advice to tackle dumping practices. The WTO mandates the member nations to provide valid justifications when imposing anti-dumping measures and comply with the principles of free market competition outlined by the WTO. Now let us see the anti-dumping laws in India. The legal framework governing anti-dumping measures in India consists of a range of statutes and regulations designed to tackle unfair trade practices and safeguard domestic industry against the negative impacts of imported goods sold at unfairly low prices. The Government of India enacted in 1985 the customs tariff, identification, assessment, and collection of duty or additional duty on dumped articles and for determination of injury rules 1985 to tackle dumping. The Customs Tariff Act 1975, as amended in accordance with the WTO regime, provides the legislative framework for the imposition of anti-dumping duties. Rules have been enacted under the Customs Tariff Act to provide a detailed framework for the procedural aspects of anti-dumping investigations and the imposition of duties. Although custom officials are responsible for collecting anti-dumping tax, it is important to note that this type of duty differs greatly from regular custom duties in terms of its aim and how it is implemented. Custom duties primarily function as a mechanism for generating income and promoting economic growth. On the other hand, anti-dumping measures are designed to address unfair trade practices and safeguard domestic businesses from the harm. Contrary to custom duties, which are imposed on all imports without exception, anti-dumping duties are targeted against exporters or countries that engage in the practice of dumping. The Directorate General of Anti-Dumping and Allied Duties (GGAD) is the apex authority dealing with the anti-dumping measures. DGAD operates under the Department of Commerce in the Ministry of Commerce and Industry and is responsible for conducting anti-dumping investigations as the designated authority. The DGAD advises the government to impose anti-dumping duties, which are then imposed by the Ministry of Finance through official notifications. Challenges to decisions concerning anti-dumping measures can be brought before the Customs, Excise and Gold Control Appellate Tribunal (CGAT). Appeals processes guarantee compliance with procedural fairness and judicial supervision in anti-dumping actions. The Directorate General of Anti-Dumping and Allied Duties thus has a crucial role in conducting investigations and making recommendations for anti-dumping duties, emphasizing the significance of transparent and accountable regulatory procedures. Now let us conclude the topic. From the foregoing discussion, we can conclude that dumping is the practice of selling goods in foreign markets at prices that are lower than those in the domestic market. It is a strategic activity employed by exporting enterprises to gain a competitive edge. Comprehending the rationales and categories of dumping, such as market segmentation, surplus production capacity, and governmental financial support, is crucial for policymakers and businesses as they navigate the intricacies of international commerce. Anti-dumping measures are used as a regulatory instrument to mitigate the negative impacts of dumping on domestic industries. These efforts, based on international agreements like anti-dumping agreement and domestic legislations such as India's Custom Tariff Act, seek to promote fairness and create equal opportunities in global marketplaces. Despite ongoing arguments about their effectiveness and economic consequences, anti-dumping regulations continue to play a crucial role in the global trade system, influencing the dynamics of international business. It must be noted that anti-dumping measures are necessary to combat unfair competition and safeguard domestic businesses, but they do harm the free trade principle. Therefore, it is crucial to find a middle ground between promoting trade liberalization and enforcing regulations. When implementing these measures, the ideals of unrestricted market competition and fair trade continue to be of utmost importance, shaping the development of anti-dumping legislation in response to evolving dynamics in global trade. The complicated interaction between the act of dumping and the implementation of anti-dumping measures highlights the intricate dynamics of global trade and the regulatory systems created to combat unfair practices. That is it for the time being. Thank you very much. Happy learning. God bless you.